Okay, so welcome, and thank you for joining us for today's webinar. My name is Santiago Marino, and I'm a content creator here at Doorloop. Doorloop is a property management software solution, and we help landlords and property managers manage their portfolios. Now, because we get so many questions about landlord-tenant laws, we decided to bring in an expert and real estate attorney. So today, we're super excited to be joined by Ernie Garcia, a licensed attorney from the state of Texas. Thank you very much for joining us, Ernie, and welcome to our webinar.
Howdy.
All right, it's great to have you today. And before we get started, why don't we tell everyone a little bit about your practice and about the services that you provide?
Yeah. So my name, again, Ernie Garcia. I'm a landlord attorney. My office is principally located in Houston, Texas, and I represent landlords, property managers, real estate investment companies, multi-family units, as well as single-family homes. We do a lot of landlord-tenant work, both in the eviction court and in the justice courts, the county courts and the district courts in the state of Texas. We also represent clients dealing with other matters, but the majority of what we do is real estate with a primary focus in landlord-tenant law in Houston, surrounding counties, and really all throughout the state of Texas.
Thank you very much for that, Ernie. And I'm briefly going to go over the agenda, and then we'll go over everything one-on-one. So the first thing we're going to do is talk a little bit about the most common landlord-tenant issues and laws that you see in your office and in your practice. We'll go over grounds to evict a tenant, as well as the eviction process, and how landlords and property owners can prevent delays or fines in the process. And then we can touch a little bit on the difference between hiring an attorney and doing it yourself when it comes to evictions. As well as let's go a little bit over what changes you see that happened after COVID. Some of the changes in the law. And then we're going to wrap it up with going over squatter rights laws and rent increase laws. All right, so let's get started with, can you give us an overview of the most common issues that you tend to see regarding landlord-tenant laws in Texas?
Yeah, for us, I guess the two most common things that pop up have to do with repair issues and with security deposit issues. These are the kinds of things that landlords either A, don't precisely know how far their duties and liabilities extend, or they've got old thinking in mind, and because they've done it that way for 20 or 25 years, they think the law is static, and they're not aware of the updates in the law. And so with the first one having to do with repairs, that's out of the Texas Property Code, section 92.056. I talk to landlords about this a lot. And essentially what this section of the law deals with are the kinds of defects on a property that materially affect the health or safety of an ordinary tenant. And so it's not, well, the kitchen cabinet's not the right shade of white. And it's not, well, I would really prefer for the staircase to go this way instead of this way. It's something much deeper than that, where the landlord has a definite duty to respond, right? And so the law, helps us in that it defines precisely where these lines are. And one of the first things that it tells us is that there has to be some kind of material effect on the health or the safety of an ordinary tenant. And so it should be very clear that someone's health or their safety is at risk. And if it is clear, then that landlord has a duty to respond. And sometimes I get a landlord to ask, well, what if they haven't paid rent yet? Well, if the front door is missing, it doesn't matter if they haven't paid rent. You have a duty, these people have to be safe. Whether they pay rent or not is not the court's concern. It's whether or not they are still safe. And so, I tell landlords, don't get bogged down with the rent. Rent is an issue, and yes, it can be resolved, but what you don't want is for someone's health or safety to be jeopardized in such a way that now you're contending with a claim that far exceeds the rent. And so, yeah, these things have to be taken very, very seriously, and the law is serious in the way that it describes, what tenants can do and what landlords must do in the event of this kind of defect.
Wow, interesting. Is there a particular health issue that you see more often than others?
So living in Texas, one of the things that we often get is, well, what about that AC going out? When the AC goes out, am I duty bound to address it? Well, I tell landlords this simple thing. If the AC goes out in the month of February, it's probably not as big an issue than if it goes out in the month of August. And so there's a drastic difference with the effect on someone's health. Imagine being in a unit that's creeping up 85, 90, 95 degrees when outside it's 108. And with the humidity, it's far, far worse. If you're inside in a structure like this, even someone in relatively good health could experience some kind of heat stroke or heat condition that could put them in the hospital and could subject you, landlord, to some serious claims because you failed to act with diligence. And so really the best defense for a landlord in these cases is diligence. Like, did you respond? Did you do something? Did you do anything? If you kept putting them off, or you flipped them the bird, or you cursed them out on email or text, just assume all of that stuff's going to come out in future litigation. So don't put yourself out there like that. Your duty is to act with diligence when someone's health or safety are potentially at risk. Don't worry about the cost so much as the potential cost of future claims. And so too many landlords get bogged down in, I don't like this tenant, or it's unfair that I have to do this. Instead, you have to presume that by not doing it, it's actually going to cost more. So keep in mind your duty as a landlord, despite what the tenant has done, and you're gonna be far better off. Landlords, as always, we welcome you to follow us on our Instagram page. If you're not a member yet, join us on Facebook. And if you enjoy what you see here, give us a thumbs up. Click that like button. We enjoy that very much. And if you haven't subscribed yet, please consider subscribing.
Would you say Texas is more of a landlord-friendly, tenant-friendly? Or?
So it depends who you're talking with. So when I talk to landlords, they're convinced, well, this is such a tenant-friendly state. I can't believe it. To which I say, right. You're just happy you're not in California or New York, where the law really leans toward the tenant. But when you talk to tenants, they're always going to argue, oh, no, definitely it's more in favor of the landlord. And the truth is, in the state of Texas, by far, the legislation leans in favor of the landlord. This is a state that heavily protects ownership rights and property interests, but that goes both ways. And so if a tenant has certain interests in property, that's where these protections stem from a deep-seated belief in the state of Texas that a person's property rights are of high value and high importance. And so the state of Texas, is going to defend a person's rights to remain on their property, whether they're a tenant or the owner. The state of Texas is deeply concerned in those things. So procedurally, I think the law favors landlords, but definitely there are tenant protections that every landlord has to be aware of.
What are some of the most common grounds to evict a tenant in Texas?
Well, I mean, the easy one is non-payment of rent. And so if a tenant has failed to pay rent, typically that's been the gold standard. During the pandemic, things changed a little bit. It kind of muddied the waters where non-payment of rent was concerned because the federal government stepped in and said, well, if somebody's got a really good COVID-related reason for not paying rent, that's not good enough to evict. But much of that has passed. And so now when we litigate, most eviction matters are raised due to non-payment of rent, but those aren't the only ones. There are non-rent lease violations that tenants are often subject to that sometimes, landlords don't pay a whole lot of attention to. For example, if someone has unauthorized occupants residing on the premises, that's a justifiable reason to terminate the lease. They might have unauthorized pets that are tearing up the yard or tearing up the wood flooring or, the windows and the doors and causing tremendous damage itself. If a tenant is negligently handling the property and causing it to fall into disrepair, that's not normal use. It's not ordinary use. These things are viable claims, even if that same tenant is paying rent on time, paying it early even. These non-rent lease violations are perfectly good causes of action for eviction. Another would be holdover. And holdover happens when a landlord terminates a lease or a lease terminates on its own and the tenant has simply failed to leave. In the state of Texas, if a tenant is subject to a holdover claim, they can be evicted. And so this usually happens with some notice that is delivered from the landlord, essentially stating the lease will no longer automatically renew. It's been on a month-to-month or is subject to a month-to-month automatic renewal, or the lease is coming to an end and I have no intention of issuing a new lease. I have no intention of moving forward. Maybe I don't even want to continue to be a landlord anymore. I want to sell the property or move into the property or just use it in a completely different way. And so the landlord draws a line in the sand, gives proper notice, and tells the tenant the tenancy ends at this point and will not continue. If a tenant overstays, they're potentially subject to eviction on the basis of holdover.
What is the eviction process like? In most cases, is it, how long does it take? Is it expensive?
Well, so if you're doing this on your own, the eviction typically in the state of Texas runs about 30 to 45 days. And it can be quite inexpensive. It can be as little as the cost of a single notice. You issue, and all evictions start with notice. And so if there is some default, right, the tenant has either failed to leave because of holdover, they have breached their lease in some non-rent issue, or they failed to pay rent, some default, the landlord can issue generally a 3-day notice to vacate. It's a demand for possession that's in writing and properly delivered to the tenant to begin the process. And many tenants respond to this by packing up and leaving. But for those who don't, the landlord has the next step, which is to file their petition in the justice court or the justice of the peace in the state of Texas, where in the precinct where the property is located. So every county in Texas is broken up into different precincts. In Harris County, where we work, we've got 8 different precincts. So if you know where the property is located, that's the precinct where you have to file. Landlord goes and pays a filing fee. Generally, it's under $150. If it's one tenant, it's a little more if there are additional tenants. But you pay the filing fee, file the petition, and within about 30 days, you're going to get a trial setting. You attend that trial. If you're successful, the court will issue a final order. And if the tenant doesn't appeal, but has remained in possession, the landlord's entitled to what's called a writ of possession at that point. They can get that writ of possession, and the county will actually forcibly remove the tenant, and their property can be removed, and then you can recover possession at that time. Naturally, if there's an appeal, the matter proceeds to a higher court. You do a lot of this over, but to the same end, a final judgment, and then ultimately a writ of possession if the tenant refuses to leave voluntarily.
And what are some of the things that landlords could do to prevent delays or even fines in the process? So
this happens so much simply because landlords are convinced that, if I enforce my lease to the letter, that's so mean. I don't want to be the mean landlord. And you get in their head that complying with the terms of their written agreement, which they enter into together with the tenant, is somehow an act of meanness. What I tell landlords is, look, you and the tenant entered into a business arrangement, and it's simply a business transaction when if they fail to comply, you send them some kind of notice, either a notice of default or a notice of non-renewal, or a notice to vacate because they are in breach. And what I tell landlords is you can avoid a lot of delay, you can avoid a lot of lost rent by simply acting with diligence to enforce the terms of your lease. That includes late fees, that includes sending written notice for every lease violation, and it includes having a game plan and knowing at this point, this is my breaking point, I will proceed with an eviction. We tend to recommend to landlords, look, if you've gotten to day 7 and you haven't received rent, because we know that eviction takes about 30 to 45 days, you're already subject to 2 months of lost rent at day 7. So if you begin then and you get your judgment within 45 days, you've limited your damages to about 2 months. You might have a deposit, so you limit to just 1 month loss. But there are some landlords who wait and they talk to the tenant drags things out. I'm definitely going to have the money in a couple of weeks. I'm definitely going to have the money in a couple of weeks. Oh, I'm going to borrow it from my mom, or I got this on the ship coming in, and it never happens. And so delay. And now they're talking about 5 months of lost rent instead of maybe just 1 or less if things go favorably. So essentially having a game plan, knowing where the line is in the sand, is what a landlord can use in order to limit loss, limit delay, and get that property, generating income again.
And that brings me to my next question. When it comes to doing it yourself or hiring an attorney, what are some of the advantages you would say that people have when hiring a professional, an attorney?
Well, but part of it is knowing all the things that can go wrong. A lot of inexperienced landlords just have no idea. In fact, many tenants are far more versed in the law than they are, and they've gone down this road before. And landlords will come to my office and say, I never had to evict somebody before, but they find that the person they're evicting, this is their 4th eviction. They're quite good at it, and they had no idea they could do this, and then this, and then this. And each iteration costs another month of rent, and another month of rent, and another month of rent, which far exceed whatever their attorney fees would have been if they had sought an attorney at the beginning. And so it's all a matter of cost. If it's going to cost you more not to have an attorney, it only makes sense to start off, because it could be as simple as just getting advice. Do I go right or do I go left? And that decision could make all the difference. You maybe never hire that attorney, but that one piece of advice from a single consultation could make all the difference in the world. I've seen it happen 1,000 times. Yeah,
totally. I agree with that. That's a great point, because people may think, if I save a little bit of money now, I'll be great. But no, that's extending months, which will cost them possibly 3-4 times more than it would have cost to hire an attorney. Right?
Potentially, yes. Or what's worse is they tried on their own. They lose 90 days just to have to start the process over. And now they're forced to seek out counsel because they don't want to do that again. When if they had just listened to their gut at first and just made the call, they could have spared themselves all this. And then I could have taught them along the way what they now have avoided, as opposed to, well, this is what happened because you failed to seek out help early on in the process. It's very easy to get any one of these pieces wrong in the process and to get turned around and be forced to start over. And so if you don't know the pitfalls, you're liable to fall into one.
Are there any fines that some people may be charged with, or I mean landlords, if not doing it correctly?
Yeah. So aside from having to start over and pay for everything, all the filing fees, there are certain fines for lacking diligence. So if, for example, a tenant says, "Look, I've got this repair that really needs to happen," and you're like, "Nope, not going to do it. I'm going a different way, or I'm looking into it and I'll get around to it." So state law says, look, if they've given you written notice and it is some issue that materially affects health and safety, and you haven't acted with diligence, and the rule of thumb is 7 days. If you haven't done it in 7 days, then they can give you another written notice that says something to the following effect. If you don't get it done within the next 7 days, I'm going to hire Joe, who is an expert in doing X, Y, or Z. And Joe's quoted me this number, which is less than my monthly rent. I'll pay Joe to do it. And guess what? I'm going to discount from next month's rent, that full amount. And a landlord says, yeah, go ahead and try. It's perfectly legal. It's what 92.056 says in the law. Another way that landlords get in trouble is with that security deposit. I talked about this a little bit at first. When we talk about fines, if you mishandle someone's security deposit in the state of Texas, you could be assessed a fee of 3 times the amount you wrongfully withhold. You know, wow. I tell landlords, look, if you can't justify a deduction, don't take it. Don't estimate. Don't take a grievance claim, right? It's like, they were such a poor tenant, I'm just not giving them the deposit back. That's not justification. Wow. If you can't point to the lease, if you can't point to some damage that you know that you can prove the tenant caused, you have to refund. And if you don't, you can get hit by 3 times the amount. So imagine a $1,500 deposit and you kept $1,000 of it, and they hit you with a lawsuit that you can't prove. Now you're paying $3,000 plus other statutory fines, plus all of their attorney fees, which, by the way, sometimes exceed that amount. You kept $1,000 and thought you were pulling a fast one, and now you're writing a check for $8,000. That's not good math, not good business.
Yeah, absolutely. Makes a lot of sense. Interesting. And Ernie, have you noticed anything, any particular changes in the law after COVID that may still be taking into effect, or
yes,
anything in particular?
So changes in the law, the CARES Act that was signed in March of 2020 still requires a 30-day notice in many evictions when there is federal funding. And so not all courts acknowledge this, and not all tenants are aware of this requirement. But if there's federal funding involved and you're a landlord, these are things you have to know, is that someone could raise a clever defense and say, you didn't give a 30-day notice, and I know that you have a federally backed loan, which applies and would require that extra level there in the law. But,
gotcha.
You know, another thing that exists now that didn't exist before is an explosion of favorable tenant assets. Sometimes it's an increase in legal aid. And so there are now attorneys sometimes in the courthouse that are just there waiting. And if a tenant's got a question, they've got a free attorney right there, and they can get on-the-spot legal advice that could tear your eviction up. If they see any error in it, they will step in and say, sorry, Miss Landlord, you don't win today because you have a filing error with your notice to vacate, or your petition lacks X, or your basis is improper because of Y. And so that exists, as well as because of sources like this, right? So there's so much content online now that tenants have access to like never before. And, you know, the landlords are, you know, behind the 8 ball here. There's so much information out there that many tenants are outsmarting landlords in these courts. And it's just a reality of what, you know, COVID necessitated tenants to get smarter. And they have, probably at a rate higher than landlords.
When it comes to squatters' rights, did that change significantly with COVID or in general?
No, I wouldn't say that in the state of Texas, you know, squatters got any additional rights. Okay. But what landlords will find is just how easy it is for squatters to come onto property, especially property you're just not keeping your eye on. If you've got a good piece of property and you're holding out for that perfect tenant and you're letting it sit, there are people who are watching. There are people who know that a vacant property can be occupied, and if they can get utilities set up and establish residency, that they've got 60 to 90, sometimes more days for free, essentially, while you go through the eviction process. You have no idea who they are, and they have no legal obligation to pay you any rent, and they know this game. And so squatters who intentionally look out for unoccupied homes have done it before and are not afraid to park themselves in a really nice property because they know just how difficult it could ultimately be to get rid of them. Now, sometimes landlords have what they think are squatters, or what they refer to me as squatters, but these are not squatters. What happens sometimes is you rent out, so you, the landlord, have a tenant, and Joe Tenant says, I'm out of here, but my cousin, cousin Ken is sticking around. And maybe they don't run this by you, and certainly Ken and you do not have a contractual connection.
Right.
The question is, who do you sue in this case? Ken's there. He doesn't have a lease. He doesn't really have the rights to be there, except that he's relying on the rights of the former tenant. And so I tell landlords, this is very easy. You sue Joe. You sue that old tenant. He's the one who signed the lease, and but for him, this guy wouldn't be in there. You sue him, and you seek to collect rent, especially if they're not paying rent. You get a judgment against the other guy. And now he may say, look, I left. I'm no longer here. Except that he didn't leave because he left a squatter behind, right? And so in this situation, you're going to want to sue for unpaid rent. You're going to want to sue the other guy. And the whole reason is if you can ever make a claim for unpaid rent, you absolutely must, because it's going to make an appeal prohibitive. When you can't claim anything like that genuine squatter, they can appeal for absolutely free, and you're just stuck with it. But when there was a lease and somebody let somebody stay in their place, you go after them and you charge rent and you make them pay some amount if they plan to appeal. That's your best bet every single time. Don't sue the squatter. You have no contractual connection with him. Sue the guy who let the squatter in. That's your best bet every time.
Wow, interesting. And normally, how long would that kind of process take when there's squatters involved?
It's no different. It's just as if you were suing for eviction a regular tenant.
Oh, interesting.
And that's true in that situation. It's true, again, regular tenant. It's true after a foreclosure. If after a foreclosure, you've got people living in there, whether they were the homeowners who were foreclosed or whether they were the tenants of the former homeowner who got foreclosed, the process is the same. It doesn't make it any faster that they have no legal obligation to you. You still have to go through many of the same hoops. And it's unfortunate that that's true. But even someone with zero contractual connection to you is still entitled, if they are a resident, an established residency, they're still entitled to the whole process.
Wow. Very interesting. Thank you, Ernie. And when it comes to rent increase laws, is that something that you see often in your practice? Or issues with it?
It actually is. So we sometimes use this in a way to motivate people to leave. So, for example, there is no rent control in the state of Texas. So you could go from 1,000 to 10,000, and there's technically nothing illegal about it. Not good customer service, but also not illegal. And so if you've got someone on the property who you know has already told you, I ain't going anywhere, and their rent was, say, $1,500, but you know that the market rent actually calls for $2,500. They just got lucky and they got stuck with a nice low rent, but it's come up and you want to raise it. You may be in a good position to say, but here's what my notice says. My notice says in 30 days, your $1,500 rent will end. And if you choose to stay, the new rent, first day of the following month, is going to be $3,000. And the reason that's important is even if they tender the $1,500, you can still issue a notice to vacate and say, nope, the rent's no longer $1,500. It's now $3,000. I'm going to sue you for that amount. And so you'll take a judgment subject to that because they've had an ample amount of time to vacate the premises, to decide, you know what, rent's too high, I will voluntarily leave. That's what the 30-day notice is set up to do. But if they elect to stay, they're subject to that rent increase. Now, so long as the rent can be increased by notice this way, if it's a month-to-month tenancy or if the lease is coming to an end, certainly with adequate notice, the landlord in the state of Texas can raise the rent really as high as they want for whatever reason that they want. They're not limited in that way. The only limitation is you just can't do it during the term of the lease. If you got a 12-month lease, you can't go 7 months in and say, I want to double the rent. But after the 12th month, you definitely can. And as long as you've given adequate notice, your tenants are subject to the fact that you have the right to raise the rent to market level and beyond. That's purely in the hands of the landlord as long as they've given adequate notice.
I understand sometimes some landlords may not like a tenant for whatever reason, and they try to evict them without a valid reason. And sometimes they can get into trouble for that, right? Like they say, oh, I'm moving into a property, and they're actually not. And they try to find cut some corners like that. Is that something that you see often of landlords trying to find a way to get rid of?
I unfortunately do. Where I'll tell you this one story is I had a property manager who came to me and said, look, I recently took over management of a particular property where a landlord drafted his own lease, reviewed it himself, didn't have anybody helping him, and they signed a multi-year lease. I'm talking a lot of years. Wow. And so now they're locked in for all these. They're 2 years in, and now he's thinking, well, my taxes have gone up and insurance has gone, everything's gone up. This number doesn't make sense for me anymore. What can I do? And I looked over the case and I looked at all the facts and said, zero. You can't do anything until this tenant is in breach. And so a landlord who wants to force somebody out could get themselves into a lot of trouble if they are found to retaliate against the tenant, if they're found to harass the tenant without cause, sending them messages or threatening eviction, again, with no legal basis. That tenant could file claims against that landlord for improper communication, for harassment, or for retaliation. And all of these can pile up in the exact same court where you might later seek the court's help for an eviction. If you've got a track record of just being a bad landlord, that's just not going to do you well. It's ultimately going to hurt you. And so the big lesson is don't write a lease unless you know about leasing, and don't represent yourself if this is your first rodeo. You're going to get things wrong, and you're going to miss some key details where you think you have a good deal. A fresh set of eyes that has seen this 1,000 times is going to show you, no, this ain't a good deal, and you need to go a different direction.
And one more thing that I understand a lot of landlords sometimes have issues with, and that's something that I believe software companies like Doorloop can help with, which is keeping records, keeping contracts. Are some landlords out there having issues finding leases, in file cabinets, things like that? Yeah,
for sure. They'll lose track of their leases. They'll lose track of notices that they claim they sent, but they don't know where they are. I think that the biggest problem that landlords have with record keeping is they don't keep good ledgers. In fact, too many landlords I'll talk to and say, so show me your rent ledger. And they're like, what was that? I'm like, come on.
What's a ledger?
Yeah. I mean, you're at least jotting down, even in a spiral notebook, these payments. And, well, I used to, but... And so they don't know, on what date payment was made. They don't know what fees are assessed. They don't know exactly how much unpaid rent is owed because they just don't keep good records. And I tell landlords, look, not only are you probably losing money because you're not assessing late fees, because you don't know when they occurred, and you're probably waiving them time and time again. If you're asked by a court to prove your damages, if you're asked by a court to prove that you are entitled to possession and they want to see that rent ledger and you can't provide it, this is the way cases get kicked out of court all the time. They're not operating as a business. They're operating like a hobby, but they're asking the court to assess their professional endeavor in a way that makes sense. And the court's natural response is going to be, sorry, you haven't met your legal burden because you're not taking this seriously enough. And so that's when they come to me and they hand me a shoebox of documents and say, please help me figure this stuff out. And if they had, some kind of software where they could very easily say on March 1st, this amount came in, on April 13th, this amount came in, but prior to that, fees were assessed, and prior to that, this was documented, and everything is there that you can easily print out and easily present to the court. Now you've got no problem with your evidence, and you've got a court that already sees you as someone who is ahead of the game because you got your stuff in order. Without it, you're showing up as a mess, and the court's less likely to rule in your favor. That's just the truth of it.
Right. Yeah. A lot of our members, they say that every time they have an issue, literally, it's like a click away. They're like, oh, you need this report? Boom. You need this lease? Let me find it. Which, I mean, 2023, I think it's a good tool to have.
Yeah, absolutely.
Sort of software.
It's something we preach. I mean, if you can't do it, and I tell landlords this all the time, there's certain things I'm terrible at. That, early in my practice, I used to try to do everything. I'd answer the phones and, I'd go and I'd file and I'd type up certain things and I would do things that I was just terrible at doing. I'd prepare my own taxes, right? And just do everything poorly, but I was doing everything. Not good business, right? And so if you could take something off your shoulders, landlords, if you could take some of these mundane tasks and let a computer do it, let somebody else maintain a filing system that makes a lot of sense, that looks neat, that you can easily refer to. That's one less thing you have to worry about. And you as a landlord can focus on the things that you are good at. Maybe that's acquiring new property. Maybe that's meeting new tenants. But record keeping, if that's not in your bag, don't pretend that it is because you're just going to do a porter. Landlords who know other landlords, who know professionals, realtors, or attorneys are the most likely to get things right. If you're going, Lone Ranger on this, you've got no help whatsoever, you're probably going to fail. In fact, you probably don't know just how off the path you are by doing this alone. If you don't have some tools in your tool belt, it's going to be harder. You're eventually going to learn, but you're going to get a few knots on the head from all the tripping and falling that you do when you really don't have to do any of that. When you surround yourself with people in the industry that have done it 1,000 times, you're more likely to have success. So, I constantly encourage landlords to go and seek out, tools that are going to make their landlording better. Because so many tools are out there. Doorloop is one of them. Having access to, a solid attorney is another one. Going and sitting in the courtroom and just kind of listening to hear what happens in real time in an eviction before you ever have to file one. All that's good stuff that if landlords aren't doing, they're leaving money on the table and just making their life harder on themselves. There's too many good things out there for landlords for them not to be, partaking in them and figuring, I just got to figure it out on my own. It's just not true.
And for anyone listening right now, anyone in Texas that might be wondering, I like Ernie, I wonder how much he might charge to help me out with an eviction or other services. Can you give us a general idea of some of your prices for your services? Sure.
So, on a very basic level, we offer a 30-minute consultation with a licensed Texas attorney from our office here. It's $199, and you can kind of hash out your case and see, do you have to evict? Are there other options that might be faster and cleaner for you? We encourage landlords to talk to us about their case to really kind of assess what their options are. If you need to start with an eviction, we start things with as low as a $1,200 retainer, and things can get, slightly more expensive, but you may find that, the investment in a retainer might itself turn the ship around in a way that, again, going on your own just can't get the job done. Sometimes a legal expert will come in. I often talk about the plumber. If you put a wrench in my hand, I'm going to end up doing more damage than I'm going to do good to that toilet. And so I'd rather put that in the hand of a professional pay for it now instead of paying more later for the mess that I will inevitably cause. And so, if there's someone out there who is interested in speaking with a licensed Texas attorney, absolutely, all over the state of Texas, we've taken cases in Dallas and Austin, as far as El Paso and Corpus Christi, our business offices in Houston, and we're happy to help landlords all over the great state.
Amazing. Thank you very much, Ernie. I'm going to go ahead and share my screen so that people can see your contact information. Would you mind giving them your email?
I don't mind it at all. Yeah. You can email directly to me. That's Ernie.Garcia at attorneyeg.com. My phone number, 832-305-7694. You can talk to one of our staff members right there to set up the consultation. If you shoot me a quick email, I'm happy to answer quick emails. Certainly, I'm not going to go back and forth, with a short novel length kind of help. But maybe you can ask a quick question, and I'm happy to answer those for those of you out there who want to shoot me an email, and maybe we can set something up from there. But definitely, if you've got some need, give us a call, send me an email, we'll set something up, and perhaps we can set things right, even if things have gone way off the track. We've seen all sorts of problems and helped all kinds of landlords to get back in line, making sure that they're making money from their business.
And one more thing, you speak Spanish.
I do. Hablamos
excellent.
español.
Hablan español, buenísimo. Bueno para todas las personas que de pronto no están seguras si quieren hacer esto, contigo pueden encontrar ayuda en español también.
Aquí estamos y ayudamos a mucha gente que habla español. Y si quisieran hablar con un abogado que habla español, aquí estamos listos para ayudar.
Fantástico. Thank you very much, Ernie. Really, really appreciate you taking the time to, go over all of these important topics with us. Really, really thank you very much. Are there any closing thoughts before we end?
No, I think we covered so much. Certainly, there's a ton more that's out there for landlords. I've got my own YouTube channel where I give, tons and tons of free tips and examples of stuff. People can find my content on YouTube. But definitely, if you haven't locked in with someone who you can go to, I'm there. There's other people out there, but I'd love to help any landlord who's just getting in the game, just has a few questions. I'm ready to help. I got a ton of experience for you.
Once again, thank you very much for joining us today. And remember, if you're a landlord or a property manager and you haven't tried Doorloop yet, go ahead and request a demo today. You can do that on our website at www.doorloop.com. Once again, thank you very much for joining us, and we'll see you on the next one.